welcome to Anchor Network, where you get updates of things happening around you and things you would like to know. I appreciate everyone who has subscribed to this channel and those who are yet to subscribe. And if you have not subscribed, what are you waiting for? Click the red button and also click the bell icon so that you'll be notified anytime we publish any news. This time around, we have wonderful news for you that you will be glad that you are aware of. Stay tuned. The Abuja Division of the Court of Appeal has been asked to determine whether President Muhammadu Buhari supplied false information about his educational qualification and certificates in the form CF001 is submitted to the Independent National Electoral Commission (INEC) before the 2019 general elections. The appellate court is in an appeal marked CA/A/436/2019, further urged to determine whether the Office of the Attorney General of the Federation and Minister of Justice is competent to file process to defend the allegation that President Buhari lied on oath about its qualifications. The appeal was lodged by three litigants, Kalu Agu, Labaran, Ismail, and Hassy, El-Kuris, who identified themselves as electorates and taxpayers. The trial are challenging the dismissal of a suit they filed against President Buhari prior to the presidential election. Trial Justice Ahmed Mohammed of the Federal High Court in Abuja had in a judgment last month dismissed the suit marked FHC/ABJ/CS/1310/2018 on the premise that it was statute barred. Cited as defendants in the matter were President Buhari, the All Progressives Congress, APC, and INEC. Meanwhile, in their 4 grounds of appeal, the appellants contended that the High Court judge erred by relying on a preliminary objection that was filed on behalf of President Buhari by the AGF to dismiss the suit. Citing several decided cases, the appellants argued that the Attorney General or a lawyer in his office cannot appear or file process for the first defendants. Besides, they urged the court to appeal to determine whether the learned trial judge was right in holding that the suit was statute barred by computing the number of days from 28th day of September 2018, when the second respondent held its primary election, wherein the first respondent was elected as a candidate of the second respondent. Arising from the foregoing, it is our submission that the learned trial judges was, with respect, wrong to have heard that the objection to the representation, the Attorney General, and ipso facto the processes were belated in that there was no objection to the appearance of the law officers and that the appellants reacted to the process filed. A court must be guided by the process before it. It is evident from the process and proceedings before the court that there was a frontal challenge by the appellants to the process filed on behalf of the first respondents by the law officers. The court was bound to rule on this issue and not sweep it under the carpet. Howbeit, it is further submitted that it is settled law that the issue of competence of proceedings or a process cannot be waived when the challenge goes to the fundamental nature of the process and not merely on a procedural aspect of the process. In the circumstances of the foregoing, we urge your lordship to hold that the reliance of the courts on the process and the refusal to strike them out was wrong. Further, we urge your lordship to reverse the decision of the court, assume original jurisdiction on the matter, and strike out all the process filed by the first respondent counsel. By Section 31, Subsection 5 of the Electoral Act, it is the information given by the first respondent, the candidate, to the third respondent that is the subject matter of the suit. It is with respect inconceivable that in the light of the clear and express provisions of Section 31 of the Electoral Act and the relief source, the court reasoned that the appellant could be challenging the information set out in a document submitted to a political party by an aspirant. It is with respect self-evident that Section 285 of the 1999 Constitution as amended cannot be referable to an event occurring at the primary election of a party since the document in issue is a post-primary document. In the instant case, it is a submission that the course of action is yet to complete until the time any person in the case the appellant has reasonable grounds to believe that any information given by a candidate in the affidavit or any document submitted by the candidate is false, as provided in Section 3105 of the Electoral Act. The document in issue in the context of the overall provision of Section 31 is the only referable to a document submitted to the third respondent, which is the one exhibited and referred to in all the processes before the court. With respect, what the court below did was to create a situation not within the contemplation of the law, and upon that basis initiate dismissal of the suit. In the circumstances of the foregoing, we urge your lordship to reverse the decision of the learned trial judge and hold that the suit is not statute barred. In conclusion, we submit that the decision of the court below be reversed on the following grounds: that the process filed by the first respondent are incompetent and ought to be struck out; that the suit is not statute barred as it does not question any act or event occurring at the second respondent's primary election; that the court assumes jurisdiction over the suit and grants the relief sought at the lower court, since we have demonstrated in a paragraph 2.7 above that there is no counter affidavit known to law in opposition to the originating summons, and ipso facto the relief sought, the appellants added. In all of this that have been reported, what the masses are concerned is just for justice to prevail at the end of the day, because we have people that are not qualified ruling and presiding issues over people that are qualified. The unqualified are ruling the qualified. The happiest moment in the life of the masses will be the day justice will be prevailed, when justice will be melted as it ought to be, because all these irregularities is something that is not really making the country to move forward, and that's why everybody does what he likes. Nobody has that moral code. Nobody wants to follow the appropriate thing, because a lot of people are really ready to do the right thing, but just because when they see that people that are doing the wrong things, they get away with it, they will just ask themselves, am I foolish? Am I stupid? Why can't I join them? And that's why you see people saying, if you can't beat them, you join them. If you can't beat them, you join them. And that has been the trend. Nobody wants to do the right thing, because people that are doing the right thing, they look so stupid and foolish. People who call themselves leader, if they could do the right thing, everybody will follow suit. That is just how it is naturally. The change must start from the top, not from down, because all this back and forth of certificates and documents has really lingered for a very long time. Nobody knows what to believe anymore. Everybody is just confused. So if this thing can really come to limelight, then we know that we are heading somewhere. And most importantly, the constitution has to really be rewritten or amended to modern day situation. It is very, very awkward and not pleasing that the number one position in the country, primary school certificates or secondary school certificates, is required. Meanwhile, when you want to get other jobs like MD or whatever elsewhere, even ordinary driver, in some cases, they will need your HND, your OND, or BSc to get to that kind of job. But when we talk of number one job in the land, they said what it requires is primary school leaving certificate or secondary school. It's something that is very, very bad. So if that thing can really be amended, it will be a good thing. So guys, that is just my own opinion concerning all of these things. I would like you to put your comment down below and let's rub minds together. Thank you very much. Bye.